Hello, everyone. Thank you so much for joining me tonight, where we're going to do some estate planning 101, one of my favorite topics. I hope everyone had a wonderful day. Earlier today, I got a text from my wife that apparently our youngest was biting people at daycare. So that's not good. I don't know if any of you have had the pleasure of the daycare world, but it's like three strikes, you're out. Third time they bug you because he's biting, you got to find somewhere else. So hopefully we can make a left turn on that little process he's doing there. Um, we'll see. Uh, Again, thank you so much for joining me tonight. Tonight's conversation is going to be on estate planning. I tend to go through a little bit of everything in terms of financial planning. In my opinion, you have to do that. It's where people think they're going to go wrong is markets moving this way or that way. A lot of times is things that are in your control, some reality of your own personal finance, whether it's estate planning, elder care planning, your social security, your health care, long-term care strategy, your tax strategy. A lot of times people neglect one or two of those things, and that item might bring down the whole ship. So, obviously I'm not an attorney. Obviously, I'm not a CPA, but I do spend a lot of time, give a lot of advice on those. My hope for nights like this and webinars like I'm about to do, it should give you a couple ideas, couple thought process, couple of things to make sure we're checking off certain boxes, and then continue that dialogue and possibly bring in attorneys and put whatever documents you feel necessary in place. Today's very much for the kind of 101s, and then I'm happy to have a further conversation in any which way you need to go. And of course, I have elder care attorneys, estate attorneys, real estate attorneys that I work with all the time. So if there's any specialized questions or scenarios that you want to run by me, I'm happy to bring in an expert to kind of give you, the exact right advice. As always, if you have any questions, you'll see a little button at the bottom of your Zoom screen for your raise your hand. So feel free to ask a question at any time during the presentation, or feel free to save at the end. I'm happy to stay as long as anyone would like in terms of answering any questions. Perfect. Let's get started. Let me share my screen again. Okay. So what is estate planning? Conceptually, people just think of their will. There is a lot that goes into estate planning. So to just touch upon a few, part of my estate plan here is, God forbid, something had happened to me tomorrow and I pass away. So obviously I have to have a business succession plan in place, which of course I do. Two, you don't get to pass away at a time of your choosing. So part of the retirement plan is to make decisions based on maybe passing away early. So it's your estate plan certainly affects your retirement situation. Gift planning, fortunate for a lot of my clients, and we'll touch upon this a little bit later, you might want to see that inheritance being passed on to the next generation. How much can I gift a year to my kids, and I get to see them enjoy it. So it's not always just, leave a big pool of money and then you pass away and it goes on. There's certain things we can do before that, not only for personal reasons, but for tax purposes as well. And of course, there's legacy planning. A lot of people think you just put your will in place and a couple of the other supporting documents, and that's it. Well, there's a whole heck of a lot of items that aren't really discussed in your will. What I always kind of recommend is, and I have myself personally, kind of what I affectionately call my death docs. Of course, it's a list of my passwords. It's a list of my thought processes. So for example, there's some real estate that I owned. I say, sweetie, you don't want to deal with these types of renters. Put the for sale sign and sell it if I was you, because I know my wife and I know the things that she probably would want to do, what she wouldn't want to do. My office, I think it's beautifully designed. You can get a nice premium in terms of rent. This is an asset I would hold. So, a just a couple pages, obviously, of the personal effects, obviously your wants and wishes that are not going to be put in the will, I would have spelled out. I want so and so to get the dining room set or whatever it may be, but just have a document that has all the personal stuff. Who needs an estate plan? Arguably everyone. Now, where I start to bug people is a concept. If there's people relying on your income, I think you should have an estate plan. If someone's 25, they don't really have any assets, certainly whether they have a will or not is not going to make or break anyone. But certainly once a situation where maybe you have a spouse or certainly when you have kids, absolutely you need to have an estate plan. Now, it doesn't need to be anything crazy. It doesn't need to be anything fancy. Um, Frankly, a lot of times you can Google wills, Google power of attorneys, living wills. I've certainly personally found some pretty good sites online in terms of reasonable documents. Now, I'm of the belief something is better than nothing. So if you don't want to pay for an attorney, put something in place. Get it notarized, and you're certainly ahead of the game. I don't even mind that early on in life. As you get older, you have a little bit more moving parts, a little bit more at risk. Then yeah, I'd lean towards an attorney. Well, your wills takes care of what's in your estate. So what is in your estate? More or less everything. Now, there's certain things that are part of your estate, but won't be taxed. Such as an example would be life insurance. Life insurance is typically not going to be taxed. We're going to touch upon New Jersey and federal, but only really life insurance proceeds that are north of the state limit, which I think for a couple is like 24 or $25 million. Uh, so in which case, everyone else on this call tonight, we're fine. You're more than fine. But everything is really a part of your estate. Now, that I'm not saying your wills handle your estate. Some of the things that are in your estate have their own beneficiaries, so they won't be going by your will. But we're going to take a little bit of a deeper dive that goes into that. Some of the things you're going to really design your estate planning goals for. One of the things that's a choice is to maintain control over your estate. So certainly happen a lot where you might have a child or multiple children that you don't want them to get money outright. A situation, maybe they're 24 years old and they get $3-4 million completely at their disposal right at the beginning part of their life. You might not want that. You might want to put stipulations in there and say, hey, I want to spread it out over the lifetime. They could take it out for these purposes, to not quite, in a lot of situations, it kind of maybe hurts someone, reach their full potential. So certainly maintaining control, what we say, like maintaining control from the grave could be a part of your estate plan. Avoiding probate. Now, probate is just the process of dealing with the state in administering your estate. New Jersey is not really that bad. Other states, classically, Florida is a pretty horrible process to deal with. People really avoid it at all costs. I'll take a deeper dive in probate in a little bit. Reduce estate and income taxes. Now, federally, again, we're talking north of $20 million for a couple for estate taxes. New Jersey, a couple years ago, got rid of their estate tax, at least for now. Now, there are other taxes, such as inheritance taxes, which we'll touch upon in a little bit. But there are definitely some plannings you can do to help mitigate your inheritance and estate tax. Certainly, we have a goal of protecting spouse and kind of children. Of course, we can have complicated situations of, maybe there was a prior marriage, prior children. You want to do what's fair. If you just don't have a will and you just leave it, you're asking for a little bit of trouble. So you want to spell these things out as much as possible to avoid conflict as much as possible for the beneficiaries. Certainly, if you have a situation where you have a spouse or children that are kind of maybe a special needs situation or disability situation, that's when we're going to incorporate different types of trust to allow for government benefits. So if you find yourself in that situation, you really need to properly put estate planning in place as soon as possible. I already touched upon one of the reasons reduce agreements among heirs. And just to kind of keep things running as smoothly as possible. That's a rather big one. Um, Shocks to the system, transitions. This is where a lot of money gets lost. A lot of rookie mistakes happen because when someone passes away, it's in a highly emotional period of time. I'm actually going to be having this as a focus on my planning and my business kind of going forward. Um, Sometimes individuals make decisions with their partner for 20, 30, 40, 50 years. And sometimes that other person is the person who made all the financial decisions. And then you wake up one day and you're thrusted into a role where you're the primary decision maker, or actually the only decision maker. You might have the knowledge or might not have the experience, and you're it, and you're making the decisions. So those windows around the transition from the working world to retirement, and the transition around a dual household to a individual household, that's when you're primed to make a emotional kind of rookie mistake that can be catastrophic. So you think you've done a good job of putting these things in place, but you just have to remember that the people that are left are in a highly emotional state. So being as clear as possible, like I mentioned before, having those additional documents and your additional wishes in place, I think help that transition as much as possible. So what happens if you pass away intestate? That's a situation where you're passing away without a will. And that just says, instead of what I want to have happen, the state of New Jersey or wherever you live is going to make the decisions for me. And so in that situation, let's say if the husband passes away, they pretty much have their set rules on who's going to get what. And obviously the closer to the individual, they get more, then the further and further out, they get less and less. But again, this is the government or the state deciding who gets what. Your intentions or your desires it's not really factored in whatsoever. So what I always want to make sure of, and the thing I always ask you, do you have your basic documents in order? So just to read through the normal ones, I normally think of the four. That would be your will, your financial power of attorney. So the document, if you no longer can make decisions on yourself financially, this person can step in and help deal with your financial reality. Your medical power of attorney or healthcare proxy. This is the person that can make medical decisions for you and the doctors can speak to. You think it's just, oh, it's my wife. They could talk to my wife. No, that's not how it works. You have to have a healthcare proxy or healthcare power of attorney. And then the last one is a living will. That's where a situation where you find yourself in a vegetated state, it's your decision to, yes, more or less pull the plug, or nope, keep me going. I'll see what this whole world looks like through the eyes of a coma. But those are typically your four big ones. Now, obviously, other big ones that can come into play is appointing a guardian if you have young children or a special needs situation. Obviously, is tremendously important. This one comes up not all the time, but it is a unbelievably tough decision, especially if you have a special needs situation. Now, what I see over and over again is people go, this is really hard, and they kick the can down the road. In other words, by doing that, you're more or less saying, state of New Jersey, make the decision for me because we both passed away. I get that it's hard. I get that it's easy to kick the can down the road, but you have to face the music and deal with that reality sooner rather than later. Because again, like I mentioned before, we don't want the state making the decision for us. So if you find yourself again with young kids or special needs situation, you have to rip off the Band-Aid and make that decision, however hard. And then a revocable trust is another kind of the big estate planning document. Very big in Florida, where we're trying to avoid probate. I do see it in time to time in Jersey. It just allows a little bit more of a seamless transition upon when someone passes away, that someone who wants to have control from the grave has already in place. And it's kind of funded during their life. Now, revocable trust, you can put money in, take money out. It's flexible, it's revocable. But once the person passes away, then it becomes an irrevocable situation, and the trustee has to follow the rules of the trust. Now, your will, long story short, deals with all the assets that go through probate. So what are the assets that go through probate? And just to repeat again, probate is the process that you deal with the state you pass away in. You more or less provide them the will. The will says who the executor is. They say, yep, you're good to go. And then the executor deals with the processing of your estate. And their job is to, for any assets in your name, for example, a house, the executor's job is to kind of move it to whoever the beneficiary is. Now, like I mentioned before, there's a lot of assets that are not going to go through probate, and the will not deal with them. So, for example, if you have a joint property, well, just to be specific, joints with rights of survivorship. You pass away, the survivor gets the property. So that is not something that goes by your will. So your will could say, all my money I'm leaving to Bob, and you have a joint property with Sue with rights of survivorship. That property is going to Sue. Your will is meaningless in that reality. Life insurance, if it has beneficiaries, it goes to the beneficiaries. It will not go by the will. Do not put your estate as the beneficiary of your life insurance. I've had a situation a little over a year ago where the person said, I don't like updating all these different accounts. I'm just going to put them all as estate. This way I could just change my will and, mix it so for everything else that I have. When life insurance proceeds go into the will, now it's going to go through probate. And now those things could be subject to estate tax or inheritance tax. So the example I had was a person passed away, but the life insurance proceeds to the estate, but his IRA proceeds to the estate. The estate is forced to pay taxes immediately. So normally, if you inherited IRA, you could stretch it out over a decade. Well, the estate doesn't have that luxury because it's not a person. So it's forced to sell it all in 1 year. And the estate tax bracket, to get to the highest possible tax bracket, you need 11,000 of income. The highest possible tax bracket as a person, you need to make like 650,000. An estate or a trust, it's like 11 grand. So, certainly as you're putting beneficiaries on stuff, consult a financial planner, CPA, an attorney. But to go back to the example, the life insurance moved to the estate, person passed away, left it to the sister. The sister now has to pay inheritance tax on that. So she had to give up like 15%. But if the beneficiary of the life insurance was the sister directly, it would pay zero. Give up 150,000 to stay in New Jersey over nothing. Again, when you're making these, it's so incredible. And this is what I always find incredible about my world as well. Someone could have a couple $1 million in their 401k, and they just hit 2-3 buttons, and they can go from 100% stocks to 100% in cash, and completely change every projection we've ever done in their whole financial reality. Or someone could just change a beneficiary, which takes 2 seconds to just signing a form, and then 150,000 evaporates. I'm always here as a resource. Even if I don't know, like I said, CPA's resources, estate planning resource, elder care planning, I can find the right answer. But just before you make any of these big, what actually are really big decisions, although it takes very little to process them, just run it by me. It takes 2 seconds. So a bank account that's in your name would go by your will. It will be prorated. But you can make let's say you have an individual account and you don't want to do that. You can put what's called a pay on death or a transfer on death account. So you could actually put beneficiaries on an individual account. So they're not a lot of people say, oh, I put my kid on my account. And so what they actually do is make it a joint account. And so when, the mom's wishes is for everything to go to the three kids equally, well, now this joint account is going to go to that one child. And sometimes that one child said, well, I help mom all the time, I'm taking it. And some, it causes confusion and frustration and stress and anxieties. So we just want to be deliberate in how we want to approach it. So there is a difference between adding a transfer on death, aka they're a beneficiary and have no rights to the account, and adding them onto the account as a joint owner. And obviously, like I said before, a revocable trust or an irrevocable trust, those are properties held in trust. They would not be going by your estate or your will. Revocable trust, I touched upon it before. A little less common in Jersey, more common in other states. But again, it's just a situation where your non-retirement money, you're not putting retirement accounts in a revocable trust, but your liquid money, you're putting in here. It acts as if it's your money. So all the tax consequences while you're alive in the revocable trust flow through onto you. But upon you passing, it skips probate, does not go by your will, and all the things you stipulate in the trust are now irrevocable and will kind of play out from there. Now, how are trusts designed? You have the grantor, that is the person who is more or less adding the assets to the trust. You have the trust agreement, which spells out, this is how I want everything to play out. This is what can be taken out. This is why it could be taken out. This is the percentages that can come out. The trust property are obviously the assets that were put into there. You could put a piece of real estate in there. You could put stocks in there. You could put bonds, cash, pretty much anything can go in a trust. And then there's the trustee. So kind of your big roles when it comes to an estate. You might have a trustee of your trust. Now they're just designed for the trust. You have a power of attorney. Those persons kind of handle all your financial affairs. Trustee, power, and executor. So the executor only comes into play after you pass away. The power of attorney is only in play until you pass away. And trustees, if it's an irrevocable trust while you're alive, the trustee controls the trust then and there. So that type of situation, let's say we're trying to get money out of your estate, either for elder care planning or estate planning. So you don't have access to that money anymore. Hence, it's irrevocable to be. If you have access to it, it's revocable. So Uncle Sam saying, no, you can touch it. It's not real. It's not really an irrevocable trust. So you can't be the trustee of your own irrevocable trust. That would kind of defeat the purpose. So money goes into an irrevocable trust while you're alive. Then a trustee is typically managing it. And then there's kind of lifetime beneficiaries of the trust. So typical like elder care situation, mom or dad put money as the grantor into the irrevocable trust. Maybe one of the kids is the trustee of the irrevocable trust, just making sure all the rules are being followed. And after so many years, 5 years, it's no longer accessible to Medicaid. It's out of your estate. And the lifetime beneficiaries might be all three of the kids. That's typically, how a trust is formed. Financial power of attorney, we discussed a little while ago. It's just the person while you're alive then help control your finances. Now there's two types, durable and springing power of attorney. Think of the spring, it springs into action. That's a situation where you say, okay, I'm fine now, so the power of attorney is no good. But once I no longer can make decisions, then it springs into action and the power of attorney is real. Well, it's a hard point to say when did we cross the line. So most of the time we always kind of recommend a durable power of attorney that's always in play. Obviously, this person you have to have the utmost trust for. Now, what's also important is you think you're good because you have your power of attorney, but all these lovely companies love to put their own little piece of it into the mix. So for example, let's say you have an account at Vanguard and you say, oh, hey, Vanguard, here's my power of attorney. And they go, okay, that's great, but we also need our form signed. Well, if you wait to have that form signed as well, maybe the parent is no longer able to sign. So certainly check with all the institutions that you have your assets with to see what their own personal rules are with regards to power of attorneys and their own additional documents. Medical power of attorney or a healthcare proxy, it's the same thing as the POA for the financial side. They can just make decisions, but now it comes in with regards to healthcare. And then the living will, like I mentioned at the beginning, situation where if you find yourself in a vegetative state, what is your wishes for yourself kind of going forward? Now, a few tips with regards to kind of preparing for an estate. One of the things you can do is you can gift 17,000 a year to anyone you want at any time. So a couple can do 34,000 a year. So for example, let's say we're trying to get money out of our estate for Medicaid purposes, we can gift to our children $34,000 a year. Now, if you give over that amount, you don't owe tax, but you're supposed to file a gift tax return. So your lifetime gift amount is like 5 million plus. So really, no one's ever going to pay taxes unless you give more than the 5 million plus. But so you can gift more, but you just have to file a tax return that just records that gave a gift of 50,000 or 100,000. Now, when you gift a gift, you're also gifting the cost basis. So something that I see all the time is, oh, I want to get my house out of my name. To protect it, I'm going to gift it to my son. And we bought the house 50 years ago for 25 grand, and now it's worth 500,000. You're also gifting him the cost basis. So when he goes to sell it, he's going to have a humongous gain on his hands. If he inherits through you passing away, there's a step up at death. So we just want to be conscientious. Anytime we're giving gifts, we're also gifting the cost basis. Side note, when we gift, let's say we wanted to gift to charity, make a charitable contribution. What I always recommend people do is, one, if your RMD time, required minimum distributions from IRAs, send the gift right from your IRA. This way, you don't have to report it as income to the state of New Jersey and to federal, especially when it comes to New Jersey. New Jersey's broke. Well, not that the feds aren't broke either, but New Jersey doesn't give you a charitable deduction. But if it comes from the IRA, it does count as a charitable deduction because they would say you don't even have to claim it as income if it goes direct from the IRA to the charity. Another thing is if you have, if you like to give to charity and you have stocks that have appreciated in value, don't give a check out of your checkbook because you're probably limited being able to deduct it, maybe because you're only using the standard deduction. Gift in stock form. So don't sell it on your end. All the big institutions will allow you to move the money in stock form. Let's say you have Apple stock at a huge gain, gift it to St. Jude's. They'll sell it on their end. They're a nonprofit. They'll know any taxes on it, and you got to avoid the capital gains. So gifting is a process. Whether it's gifting your kids or gifting to someone else, just run it by me. It certainly can't hurt. For a lot of my clients who, let's say, I tell them, well, based on their financial plan, you could spend 120,000 a year. And now they're both retired, and they're like, we're perfectly fine budget wise. We don't yearn for anything, and we're spending between 90 and 100,000. Well, I always tell them, the 120 is like your salary. If you only spend 100,000, you get the 20,000 extras play money. Use that 20,000, give to your kids during the holidays. And as long as, hey, we're staying within our budget, that means our financial plan, I'm comfortable that we're never going to outlive our money, and you're giving them part of your annual budget. I hate when we're giving them, what I always say is like part of the machine. Don't touch the machine. The machine produces the budget. When you give away 50 grand and 100 grand, well, now you're going to impact everything. But if we say, all right, well, this machine we build, this pool of money can provide you 100 grand a year, do what you want with 100 grand a year. If you spend 70, fine, give away 30. If you spend 95, give away 5. But don't spend 100 and then say, oh, my kid, I want to help him with the down payment, do 20. Well, now we're eating into that machine. So figure out what the budget is and then carve out your reality and find your own personal sweet spot between spending on yourself and charities and giving to your kids. But certainly have a design around gifting anytime you're gifting to anyone. Yeah, like I mentioned before, it's even bigger. The lifetime gift amount is $13 million. So sorry, move that 5 million I said to 13 million. Now, one of the things, or a few different exceptions to that gifting amount rule is 529s. So 529 is a college savings vehicle where you can do 5 years up front. So that's a good chunk of change that gets to be out of your estate. Now, 529s, I don't even really understand why they exist because they kind of break all the rules. So the government says only an irrevocable trust is outside of your estate, but you can't have access to it. You can't touch it. It's not for you anymore. It's for someone else. 529s, you are the owner of it. You get to control it, but it's held outside of your estate. Really nothing quite like that. So 520s are a fantastic vehicle. You put money in. Now a couple states give you state tax deductions. There is no federal tax deduction, but it's growing tax deferred. If it comes out used for school, it's tax free. And they also changed the rule that if you don't use it for school, you can utilize $35,000 to make Roth contributions. So it's a really good deal when it comes down to it. So going back to the example I gave before, client says, I tell them their budget could be 120, they only spend 100, and they have 20,000 of extra. Beautiful. Plop some money away into 529 for the kids, tax-free growth, really forever. Whether it's going to be used for retirement or for school purposes. Now, if you're giving a gift and you're paying school tuition, don't worry about anything. Or for medical purposes, you don't have to worry about filing a gift tax return. Life insurance, I'll just briefly touch upon it. Like I said, you don't have to pay estate tax on it. You don't have to pay inheritance tax on it if you list the actual beneficiaries. It's held outside of probate. Now, again, New Jersey doesn't have a humongous probate issue, but certainly, people's estates 6 months, a year to kind of go through. You want to have a pool of money that you can quickly tap and, free up money for the funerals and living expenses and paying off debts. So having some pool of money that's liquid and available, that's not going to be locked up in an estate account until everything settles with the final tax returns is a worthwhile thing. So, life insurance wise, what I always kind of tell people is, when you're 20s, 30s, and 40s and you got young kids and a mortgage, you really want the bulk of it in term, cheap. Having a $50,000, $100,000 policy that you keep in some sort of forever policy, whole life policy, or a permanent policy is not a bad thing to have either. Again, this is just kind of the needs level. You need to have term insurance to protect your risk. You need to have a little bit of liquidity come when you pass away. Now, anything over and above that, yeah, then we're trying to provide an inheritance, trying to provide a legacy, and that to each their own. You find your own personal sweet spot, makes you happy there. Elder care planning. So again, the bulk of tonight, I wanted to really just discuss the estate planning basics. Like I said, you have your 4 main documents in place: your will, your power of attorneys, your healthcare proxy, and your living will. You don't have to go too fancy of it. The more complicated your situation, certainly you should deal with attorneys. Guardianship's very important. Revocable trusts, depending on your personal situation, if it speaks to you, to have much more control. Be very conscientious when you're putting something in a joint name. You think, oh, this person's helping me, but you're also changing your estate reality. Life insurance and beneficiaries always have life insurance and retirement accounts always have beneficiaries on them. And so I just want to kind of recap the bigger ticket items. Elder care planning, that is the process of planning for assisted living facility time when you need some skilled care. It's not easy. There is no perfect solution. And the reason for that is it's a pretty big problem. This tends to be more of a woman's problem than a man, in that it's like 7-to-1 women utilize some kind of long-term care expense compared to men, and women tend to last longer. It's kind of counterintuitive. It's the healthy ones that really need to do the long-term care planning. The unhealthy people normally it's fairly quick. So elder care planning is the process of say, all right, I might have to go into assisted living facility. In today's world, in New Jersey, it might cost me 150 grand a year. It's like college and elder care planning are the two things that have the highest inflation rate. It could be $400,000 or $500,000 hit. Now, when it comes to elder care planning, what I always focus on is my job is to get the two of you or just you through retirement. If I can do that successfully, that is my priority number one. So for a lot of people, I say, don't worry about it. Don't get long-term care insurance. There's enough to protect you. All it's really impacting is inheritance. Now you can say, no, I want to carve out some for inheritance, then so be it. Then what we're really saying is I'm going to buy some long-term care insurance costing me $4,000. So my budget that's $100,000, I'm going to spend $4,000 less to provide myself with the peace of mind of doing inheritance planning. If that's your whatever makes you happy. But for people that don't have long-term care insurance, and we want to be prepared that we just don't kind of unnecessarily lose money to the healthcare expenses, you would possibly sit down with an elder care attorney and maybe do some trust planning around that. Now, what I always kind of tell people are, if I don't have long-term care insurance, we have to address the risk, meaning have the conversation. We'll decide, we'll self-insure the risk, we'll do elder care planning, or we'll get insurance. But if we didn't do the insurance, typically early 70s is you have a hard conversation and you run out probability and say, all right, well, based on the assets we have, we should protect some of it. And then you bring in an elder care attorney, they might set up some irrevocable trust. Typically, it might be a situation where one of the trustees is your kids. Now, a lot of times, let's say money goes into one of these trusts, money could be paid out to the lifetime beneficiaries and find its way back to mom and dad. Didn't hear me say that. But, there's different things that you can kind of do to get stuff out of your state, but provide some flexibility. But like I said, for elder care planning, I typically want to have that hard conversation in your early 70s. And again, a lot of times I sit there and I say, I would do nothing, because it's not a guarantee, it's just probabilities. More or less, it's a coin flip, whether you're going to have a long-term care event or not. And then another coin flip to say, well, did you have a $70,000 long-term care expense or $370,000? It's just kind of probability. Normally, it's about 25% of the time where you have a long-term care expense of a high dollar amount. So that's a good chunk of change that maybe nothing happens. So sometimes you find your own personal level of comfort and personal level of peace of mind of, all right, I've put some trust in place for inheritance tax planning purposes, or a little bit of we'll see what happens. It was all, I want them to look as a gift if they get anything at all. There's no right or wrong, as long as you say, I educated myself, I understand the probability, and I came to a decision based on it. Sadly, a lot of times it's the other side where it's just like, I didn't plan any of it and life happened. And, that's where people lose a substantial amount of net worth. For the most part, like I said, I just wanted to kind of go over the basics, give you some tips, give you something to think about. Certainly for your own unique situation, shoot me an email. I'm happy to, run through the scenario. Maybe I know it, and maybe I'm like, ooh, let me just check with an attorney and kind of get back to you on it. Estate planning, you don't have to do it every year. As your life changes and updates, sure, you might need to do it. And then, I don't know, maybe every 10, 15 years is plenty. Typically I tell people, like, as you approach retirement, you want to get that one final probably will, because everyone has I have my will from when my first kid was born. Yeah, that we need to retire that one. Typically in your 60s, you get kind of that final one, and then you add that wrinkle in the 70s if elder care planning makes the most sense for you. In saying that, if anyone has any questions, feel free to raise their hand. Okay, as always, feel free to give me a call, shoot me an email if you have any follow-up questions. But again, thank you so much for joining me tonight, and I'm sure I'll talk to you all soon. Have a good night, everyone.